I think the only plausible way of fighting the activism of the Roberts-Scalia court is by convincing them that we are right about what the Constitution means. And so the classic example is going... Convincing them, yes, convincing judges like Geof Sutton, perhaps the most conservative Bush II appointee on federalism issues, that he has to uphold the constitutionality of the Affordable Care Act. The only hope we have is by arguing strenuously from the sources that they purport to care about that they can't do it. They can't be activists in this way. And it won't work all the time, but at least when they don't, we'll have their arguments, their sources to throw back in their face, and sometimes it will. And it did with Geof Sutton, and that's transformed the debate. And that's what we've got to believe a little bit in the law. We've got to believe a little bit that we can win these battles not based on politics, not based on getting judges that we want, because we probably won't have them for a while, but based on what the law requires. And that's, until we do that, we're going to, as long as we view this as counting to 5, when we don't have 5, we're going to lose.
Doug, I love that argument about Geof Sutton, and I would make it if I were sitting in this seat. But from this seat, I have to ask you, he's a federal appeals court judge, and you had some pretty good precedent in that case. If he's a Supreme Court justice and you're up there, none of those precedents are ultimately binding. And Jeff's argument that you are in a land of much more radical indeterminacy with respect to the shackles that you are operating under, assuming you're right that Sutton was as cynical as you describe and yet bound by precedent. His bosses, which I'm not conceding, but let's assume he's chomping at the bit to strike this statute down, and he just can't do it. That is not the case at the Supreme Court, right? At the Supreme Court, if you're chomping at the bit to strike it down, and you really want to do it, you can do it if you can count to 5. And so, why not take very seriously the count to 5 dimension? I mean,
well, I think obviously 5 matters at the Supreme Court. That decides who wins cases, and obviously you have to argue to get the votes of either Justice Kennedy or any other justice that you think could swing to your favor. I mean, the Affordable Care Act, I mean, if you take seriously Justice Scalia's concurring opinion in Raich, he should uphold the Affordable Care Act. If you take seriously Justice Kennedy's decision to join Justice Stevens' even more sweeping majority in Raich, he should uphold the Affordable Care Act. I think that Judge Sutton's opinion, which cynical is the wrong word. I mean, Judge Sutton's a very conservative member of the federal judiciary. I read his opinion, and I was struck by how fair and thoughtful it was throughout, and how it took every argument that was made by both sides and kind of said exactly what is right and exactly what is wrong with it. I think that opinion will be a powerful marker that people like Justice Kennedy and Justice Scalia have to overcome if they want to find it. And I don't know that they will after that opinion. I don't know after reading Judge Sutton's opinion in that case, the conservatives on the court will go there.
Well, I don't know either. And in fact, I think, Justice Scalia's opinion in Raich gives me some reason to doubt whether he wants to go there. Right. As a preliminary matter, I was just taking your assumption that the default position of the conservative judge in that situation is to want to get there. And my only point is, if you want to get there and you're a federal appeals court judge, that's a much harder proposition in the face of binding precedent than it is at the Supreme Court, where that precedent isn't really binding, even when it seems to be.
And I guess the only thing, and I'll just say this quickly, is, I mean, the only the thing that at least some of the conservatives say is binding is the text and history of the Constitution. And so if we're going to win arguments before that court, we better take those arguments, take those sources damn seriously.